This is case number 241-392-FY, 241-393-FY. These are the people state of Michigan versus Darius McCrary. Appearance for record.
Good afternoon, Your Honor. Sarah Brunner, Assistant Attorney General for the people.
Good afternoon, Your Honor. Paula Lofton on behalf of Mr. McCrary.
Good afternoon, Your Honor. Lindsay Abramson on behalf of Mr. McCrary.
Mr. McCrary, good afternoon. State your name for the record.
Afternoon, Your Honor. McCrary.
So I have two waivers here on both cases. So Mr. McCrary, please raise your right hand.
And Your Honor, he will be affirming to tell the truth due to his beliefs.
That's fine. Do you swear or affirm, subject to the pains and penalties of perjury, testimony you give this court will be the truth, the whole truth, and nothing but the truth, sir?
Affirm.
Put your right hand down. You do have a right to a preliminary examination in both cases. Do you understand?
I do.
Examine the complaint and witnesses in support of the prosecution under oath in my presence in both exams. Do you understand?
I do.
It's the prosecution's burden of proving probable cause. These two felony charges were committed in the city of Pontiac and you're the individual that committed them. Do you understand?
I do.
And at the exam, you do have the right to testify and offer evidence, have your attorney examine and cross-examine all witnesses. Do you understand?
I do.
And at the end of the exam, if I find that prosecution has not met the burden of probable cause that these two crimes were committed in the city of Pontiac and you were the individual that committed them, I can dismiss the charges or reduce them to misdemeanors if possible. Do you understand?
Yes, I do.
By waiving the exam, you'll be bound over as charged in Sixth Circuit Court to potentially stand trial. Do you understand?
Yes, sir.
I'm pretty sure there will be a bond argument, but until that's made, your bond and the conditions will remain the same until amended or modified by a Sixth Circuit Court judge. You understand?
Yes, sir.
After speaking with your attorneys, Ms. Lofton and Ms. Abramson, is it your informed decision to unconditionally waive these exams in both cases and be bound over to Circuit Court?
It is.
Waiver of these exams is not subject to reversal or appeal after today. Do you understand?
I do.
Is anyone promising you anything, threatening you, or forcing you to waive these two exams?
No, sir.
And you're waiving both exams knowingly, intelligently, and voluntarily. You understand the consequences of what you're doing?
I do.
Brenda on behalf of the people.
Your Honor, the people also waive their right to the exams.
All right, I find that Mr. McCrary has waived his right to examine both cases knowingly, intelligently, and voluntarily. He understood the consequences of doing so. Has not disclosed anyone on this record threatening him, promising him, or forcing him to waive his right to have his preliminary examination in both cases. So you're bound over. Therefore, you're bound over to Sixth Circuit Court as charged in both cases. Your arraignment date will be 7 to 10 days from today, but they'll reach out to the public defender's office and you and let you know that date. All right. So, if bond continued, are we making a bond argument or we're all set?
No, Your Honor, if I may make the argument.
You may.
Thank you, Your Honor. We believe, as we have communicated, not directly through you, but through your division, I let your division know on, I believe, Monday, that we believe that the order issued by this honorable court a week ago, with all due respect, was not a lawful order because it did not give Mr. McCrary a bond, which he is legally entitled to under the 8th Amendment, as well as Michigan law, MCR 6.106B1, which the prosecutor agrees with this argument that the court must set a bond. In this case, he does not qualify for a no bond due to, it's not a murder, it's not criminal sexual conduct or anything like that. And the only case he would be eligible for no bond would be the case in Judge O'Brien. The court can revoke a bond, of course, as the court knows, when someone is on release and violates that bond. But this is a new case, a nonviolent charge that does not meet anything like this in the statute, and he must, by right, have a bond. Now, the issue of what the bond should be is, of course, for the courts, but we believe, even if the court, we believe the court must give him a bond under the law, but he's also entitled under the Eighth Amendment and the applicable Michigan law, People versus Gia Cologne, that's 16 Mishap 352, that Mr. McCrary is entitled to a reasonable bail. And the Eighth Amendment prohibits bail being set so high as to function as a denial of bond altogether. Mr. McCrary is already being held, and I know some of this is repetitive, and I'm sorry for that, but he's already
Yeah,
being held on.
Yeah, I understand that. I just want you to get to your argument. No disrespect, but I understand he's being held on 118,000 out of circuit. court, so
Right,
that doesn't-
and I just felt the need to, I have to say that again, because if he's given an even higher bond, we don't think the bond should be any higher than what he owes. That would serve as essentially a conviction before trial, and the whole purpose of these cases are to have him pay child support. So we are asking again for 5,000, no 10%, and do not believe the court can enter a no bond order. Thank you.
Ms. Brenda?
Your Honor, after having a chance to look more into the statutes, I think that that's accurate, that the no bond doesn't apply in this type of case. I would ask again that you set a bond. I had suggested last time 250,000 cash surety. I think that that would be reasonable to make sure that he, if he bonds out, that he has reason to return, unlike last time.
So I believe there's what's the cost for the tether? Because there was a tether on him, and then when they pick up, he don't have it, so he's liable for that. What was in the $112,000 bond? More specifically, was the extradition cost in part, because I'm going to apply that one. If it wasn't in O'Brien's case, I'm going to put that on this case, because we had to go get him. Taxpayers in this state had to go get him.
Yes.
So if those two questions can be answered, that could be his bond, appropriately cash.
The bond is approximately 15,000 for the two files. It was 7,000 on one and about 7,800 on the other. Judge O'Brien did not tell us the numbers he was factoring in. He did ask me that same question about extradition, so I'm assuming he factored it in, Your Honor, but I can't tell you for sure. I know he went by the amount of the arrearages, which is, just over 82, and somehow we landed at like 112, but he didn't tell us how.
So I grant the motion. I'll set it at 25,000 cash.
Thank you, Your Honor. And just to be clear, because I noticed, I checked the Clemmis website before I signed in. The jail already has it a bit wrong. They're showing the absconding bond to still be $100 and no bond on the child support case in front of you, just so you're aware.
Okay.
I just want to make sure it's on the right case numbers.
The child support should be 18,868.32 posted in his name. I don't know why that's denied. I never denied that one.
Right.
the,
I just wanted to let you know
right.
what the website shows.
I don't know. I can only control how 50th District updates his record. So yeah, if there's any questions, my file is the most accurate. All right, so we're all set. His bond 25,000 cash, no 10%, no surety.
Thank you.
Judge.
Thank you so much, Your Honor.
This is case 250350 FY, People State of Michigan versus Miranda J. Fisher, also known as Miranda Lovelace. Here's the record.
Good afternoon, Your Honor. Sarah Brunner, Assistant Attorney General for the people.
Wilson appearing on behalf of Ms. Fisher. Your Honor, I think we do have a resolution in this matter. My client will be pleading. I was going to ask Ms. Brunner if she has any issue with her pleading no contest to disorderly conduct. I do have a copy of the police report as a factual basis. So we have the judge. In turn, the Attorney General will dismiss the counts 1 through 4 failing to pay child support.
No, I don't think a no contest plea is necessary. I would want her to plead guilty to the amended misdemeanor. So Judge, what I would want to do is amend count 1 to a misdemeanor disorderly person pursuant to 750.167 paren 1 paren A. And if she wants to enter a guilty plea to that, then I would dismiss counts 2, 3, and 4.
She'll do that, Your Honor. A no contest plea is the same thing as a guilty plea without a factual basis, but she'll do that.
All right. Ms. Fisher, please raise your right hand. You swear or affirm subject to the pains and penalties of perjury, you testimony you give this court, be the truth, the whole truth, and nothing but the truth.
Yes.
You may put your right hand down, so you do have a right to go to trial before felony charge in this matter, do you understand?
Yes.
All right, that trial will take place at the Oakland County Circuit Court, you understand?
Yeah.
15 people who live here in this county of Oakland will be randomly selected by your attorney and the prosecutor through a process called voir dire as jurors in that case, do you understand? And at that trial, it's the prosecution's burden to prove you guilty beyond a reasonable doubt of these 4 counts of child support failing to pay, you understand?
Yes.
In the trial, you do have a Fifth Amendment right to remain silent. You don't have to testify, you represent the defense, and that silence cannot be used as guilt against you, you understand? Right, but you can waive your right to testify at that trial and represent the defense. You're not required, no one can force you, you understand?
Yes.
At the end of that trial, 3 jurors will be dismissed, 12 will deliberate. They must return a unanimous verdict of guilty or not guilty to each count, you understand?
Yes.
The counts in which they can't reach a unanimous verdict, the court will declare a mistrial. Prosecution can try the case again, or they may elect not to, you understand?
Yes.
All right, you do have a right to see, hear, and question all witnesses in open court against you, do you understand?
Yeah.
All right, if you wish to have witnesses come testify on behalf of your defense in trial, that certain court judge will sign subpoenas to get your witnesses there, do you understand?
Yes.
Your Fifth Amendment right to remain silent at trial, do you understand that right? Any questions about it?
No.
All right, as you stand here now, you're still presumed innocent until proven guilty beyond a reasonable doubt, do you understand?
Yes.
All right, so a disorderly person is a 90-day misdemeanor or a fine of $500 or both. In exchange to pleading to that amended count 1, Ms. Brenda says she'll agree to dismiss counts 2, 3, and 4, the felony child support failure to pay. You understand that?
Yes.
Outside of this offer, Ms. Brenda, is anyone else offering you anything, threatening you, or forcing you to waive your right to go to trial?
No.
You currently on probation or parole?
No.
Citizen of the United States of America?
Yes.
All right. My final question is, you're entering this guilty plea knowingly, intelligently, and voluntarily. You understand the consequences of what you're doing? All right, factual basis for the plea. I know there's a lot of different dates you can use, Ms. Brenda, so go ahead.
I can assist, Your Honor, if you'd like, or if defense counsel wants to do it, I don't care.
The attorney general will take that one states.
Okay.
So between the time periods of October 1st, 2020 through January 31st of 2021 and March 1st of 21 and December 31st of 21, were you under a child support obligation in the city of Pontiac, County of Oakland, state of Michigan?
Yes.
And during that period of time, you were a disorderly person because you could have made more payment efforts than you did. You could have paid something more than you actually did. Is that correct? People are satisfied, Your Honor. Thank you.
That's right, ma'am.
Court is satisfied with the factual basis of the plea. Plea was entered into knowingly, intelligently, and voluntarily. The Commissioner understood the consequences of doing so. Has not disclosed anyone on the record threatening her, promising a portion of her right to go to trial. So we'll accept the guilty plea to count 1, amended charge to disorderly person. 2, 3, and 4, child support felony to pay. The felonies are dismissed for prejudice. There's no objection to immediate sentence.
No, you're.
No objection, Your Honor.
Anything on behalf of Ms. Fisher?
Your Honor, my client, ended up paying all back to the only child support. She has had a closed head injury. And I've been doing this a while. My first one is literally made all the back to payments, before we even got to an exam, not a delayed sentence or anything like that. She's got family help. And luckily she did, her father did end up helping her make all back payments for her. We'd ask for a nominal fine, Your Honor. She doesn't have really any resources. She's just living off her family.
Same thing for our person.
Your Honor, I would just ask if she has any jail time, you give her credit for the time served and the mandatory fees of $75 crime victim right and $50 state.
Okay. I know she was in there on the September 17th. When she got back to me on the 30th, she was not ill. When did she get released? So 3 days? She was in there 3 days?
I thought it was 5, but I'm not sure.
Oh, you got arraigned on this case. You may have, I go from the arraignment date on the case, so. You got out on the 20th, so 17, 18, like, so 4 days. So, we'll give you fines and costs of $125. That's $75 for the crime victims. Plus $50 for the state minimum costs. we'll waive, court costs, and then we'll say, sentence to 4 days, Oakland County Jail. Credit for 4 days served, and then, that 125 is due honor before I give you 30 days to have that in, so that'll be 12/15/2025. All right. So you're all set.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. I'll prepare that amended complaint and the nulli pros for the other counts.
Thank you.
Thank you, Judge.